I would like to begin by reading out a short statement, which in return I will ask you and the council to confirm is correct. I hope that is okay.
Yes, please.
The hearing is in the matter of CFI-061-2020 before Justice Wayne Martin, and the hearing is being held by way of a video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on Justice Wayne Martin's instructions. The claimant is represented by Simmons & Simmons Middle East LLP. Lead counsel is Zoe O'Sullivan, QC.
Good. Thank you, Ms. O'Sullivan. Now, I'll hear from you. I can tell you, if it helps, that I've read all the materials. I can't profess to an intimate knowledge of all the exhibits to the affidavit, but I've skimmed what appeared to me the most significant documents, and I've read the affidavit and the skeleton arguments. I don't know if that helps.
My lord, yes, it's very helpful. And I assume you have access to the electronic bundle at this moment.
I do. Thank you.
I can certainly take you to some of the exhibits. I am somewhat in your hands, as if I'm doing.
Only if you feel only if you feel you need to, Ms. O'Sullivan. As you know, I have a background in these matters, albeit in a much earlier time and in a different case. But I'm aware of the general context. I'm aware of the investigations, and having read the affidavit, I'm aware of the current situation. So really, I mean, I don't want you to labour the points, and I've given anxious consideration to them all, but unless there's anything in particular that you want to draw to my attention, I'm aware of all the issues.
Yes, thank you very much, my lord. Yes, there are a couple of matters that I want to raise in connection with the duty of full and frank disclosure. Can I begin by just clearing up the notice point, on which we're very grateful for the input of the court? This application is being made without notice, albeit informal notice was given to Dr. Shetty and his lawyers on the 9th of September, and they have made some, they have engaged in correspondence. And in fact, we've asked for consent. Consent has not been forthcoming, but I will take you to those documents shortly.
Yes.
The reason why we're going on notice, despite having given informal notice, is that there does remain an urgent risk of dissipation. And
so you meant to say the reason you're going without notice, I think, is that what you meant to say?
I'm sorry, yes, did I misspeak? Yes, without notice. Sorry. Yes.
Yeah,
we thought it appropriate to give him a few days of informal notice, but any further delay would cause Barclays serious concern, which is why we're proceeding today. And we accept, of course, that this means that Barclays is under a duty to make full and frank disclosure, and the evidence has been prepared on that basis. And we also accept that any order that the court's minded to make would have to continue only to a return date, which would have to take place by my calculation by next Tuesday, unless the parties agree otherwise.
Yes.
There are two matters I want to raise on full and frank disclosure. Firstly, the correspondence from Dr. Shetty's lawyers, which begins, if you can go straight to page B88 in the bundle.
Yes. Yes, I have that. Thank you.
If you scroll down, you'll see the first response, which is at the bottom of B88 from Mr. Figoli, I think his name is, of Onoma.
Yes.
And essentially the points being taken there is they want to see the documents underlying the principal debt due from UAEE.
Yes.
And the response, if you scroll up to B88 from my instructing solicitors, we sent them the ISDA master agreement and pointed out that the guarantee had been provided some time ago.
Yes.
And then if one scrolls down to, then I'd like to draw your attention particularly to page E1.
Yes, let me just find that. Just a moment. Sorry, I'm being a bit ham-fisted with all of this. I'm just almost there.
I'm hoping if you type in E1 and find page, it will take you there.
Yes. All right, yes, I have it. Thank you.
So this is on the 15th September, and again, I'll invite you just to skim read that.
Yes. Thank you.
I mean, in essence, one can see there that what's being sought again is supporting underlying documents, although there is a passing reference at the bottom of page E1, which says, my client refutes your allegations regarding the risk of dissipation. These are groundless and they come with significant delay when the assets are already caught by multiple existing freezing orders. Now, those are all matters which are expressly addressed in the evidence and submissions. Yes. But I draw that to your attention, and it seems to come almost by way of afterthought.
Yes.
Now, the reason why, sorry.
No, please go on.
I wanted to draw your attention to the terms of the guarantee, which essentially shows that these are legally misconceived.
Yes.
The guarantee itself is at page B14.
Yes, I'll just get back to that.
I need to say a little bit about the underlying claim, simply because the point has been taken that Barclays have not made full and frank disclosure of the underlying documents. Yes. So there is the guarantee of the 7th of January 2015. As you know, it's given in respect of an earlier master agreement of the 3rd of August 2012. The signature, if one goes down to B20, is clearly that of, well, it purports to be the signature of Dr. Shetty. Yes. And as you know, we've obtained expert evidence which concludes a very high likelihood that that is in fact his signature. Yes. I wanted to refer you specifically to clause 17.4 on page B19.
Yes. And is there such a certificate in the evidence?
Well, there's a demand, yes. I can. The
demand. Yes, right. So it's demand you rely on. Yes.
Yeah, it's
demand.
It's a conclusive evidence clause. Essentially, this is an indemnity. It's a pay on demand, argue later type arrangement, despite being described as a guarantee. So that's why the ONIMA SID inquiries are in effect legally irrelevant. And in any event, none of this goes to show that we don't have a good arguable case. I mean, these are all matters for trial if they want to say that there's no underlying debt. So that deals with the main point that has been raised. And I can show you, since you've raised it, I will show you the demand, B32.
Yes. Yes, I have that. Thank you.
You'll see this was sent to email addresses. And as you know, we're seeking permission to serve Dr. Shetty at those email addresses. And it's quite clear that he is receiving those emails because his lawyers responded to this. So there is the notice of demand. And you can see this, of course, is in respect of defaults by UAE on a number of underlying FX transactions. If you go to page B29, you'll see a list of those. This is the annex to, this is a calculation of the early termination amount in a letter signed by Mr. Homburger, who is the deponent of the affidavit. And there you are.
So where do I find the amount demanded in the notice of demand? I've got the letter.
Take that to B32.
Yes, the letter of the 28th of April. Oh, yes, 129,807. Yes. And the amount that you seek, the amount for which you seek the freezing order adds interest since then.
Yes, and costs. There's some headroom. I wouldn't suggest that the interest amounts to takes it up to 135 yet. That is simply for some headroom for interest and costs.
Yes, all right. Okay. Good. Is there anything else you'd like to take me to? The issue that I think is perhaps the most potentially contentious, and to which I've turned my mind, is this risk of dissipation issue. Yes. And just so that I'm sure I've got your arguments on this, as I would understand it, you accept that there is no evidence of actual disposal of assets except for the evidence relating to the sale of the attempted sale of the aircraft. Correct. That's right, isn't it?
Correct.
But you say that I should nevertheless be satisfied that the risk of dissipation is sufficient to grant the order because there are allegations of widespread fraud involving companies in which Dr. Shetty was a significant operator on any view. The evidence also that you rely on in relation to the market having been misled in relation to Dr. Shetty's shareholding in public listed companies, his continued presence in India,
Yes.
notwithstanding that he's lived his life, most of his recent life in Dubai, and that transport between the two countries has recently been restored.
Yes.
And the fact that he has, given the size of the claims, he has every incentive to try and preserve assets from those claims. That's basically it? Have I missed anything?
I would add one further matter, which is that we've asked him to consent, and there's been no consent, and there's been no counter proposal, for example, to put up specific security for the claim. The only points that have been taken are essentially that there's no underlying debt, there's been no counter offer, no realistic recognition that Barclays are entitled to some sort of assurance. So there's that as well. And I would say that, of course, I mean, it's well established in the authorities that the court doesn't simply say dishonesty is alleged, therefore there must be a risk of dissipation. It's more subtle than that. But we say that you can draw the inference because of the nature of what's alleged against Dr. Shetty, of which there is at the moment very strong prima facie evidence. Of course, he may acquit himself at trial in due course, but at the moment the evidence is very strong on a prima facie basis. And it is evidence that suggests a propensity to conceal and to use a network of offshore assets so as to benefit himself personally in companies controlled by him at the expense of the companies of which he is a founder.
Yes.
And we rely on, for example, the concealment of the MOU under which he was holding 20 million shares for the Bin Butties, which is obviously material that ought to have been disclosed to the board and in the financial statements and to the wider investing public, and for which Dr. Shetty has not specifically disavowed responsibility. We also rely upon the undisclosed share pledges, and we also draw your attention to the muddy waters, for example, identified overpayments in respect of a construction project at the National Women's Hospital, where they said there was evidence of serious overpayments to a company owned and controlled by Dr. Shetty. These are very serious matters, and certainly sufficient in my submission to establish a real risk of dissipation.
Yes. Okay. The only other matter I just want to clarify is the delay issue. You accept, of course, that the application should have been brought earlier. You say that there are reasons for that, that the delay is not inordinate, and that there's no evidence of any prejudice as a result of that. Is that, again, got your argument in a nutshell?
It is. I would preallay particularly the approach taken by the English Court of Appeal in the Bavaguthu case, which is essentially, if there remains strong evidence of a risk of dissipation, the court ought to grant the freezing order, notwithstanding the delay.
Yes. Yes. All right. So I understand that.
Factor, but it's not a punitive jurisdiction to deprive a party of what would otherwise be a clear entitlement to relief. And of course, we do give the cross undertaking, which Barclays is obviously in a position to meet if it turns out that the order shouldn't have been granted.
Yes, quite.
Yes.
All right. Well, that answers my queries. Is there anything else you'd like to say, Ms. O'Sullivan?
Yes, there is one point, and it's a matter of some delicacy. So I think at this point I'm going to have to ask you if you would sit in private. And I think we will also be asking you for permission to redact this section of the transcript for a period of 8 days from today, and I'll explain why in due course.
Yes, all right. Well, I'll alternatively make those orders. So the court will now move in camera, and I will also direct that the transcript be redacted for a period of 8 days, subject, of course, to any order that I might make reversing these orders after I've heard what it's all about.
Of course. Thank you very much, my lord. Essentially, Barclays has become aware of an attachment order made by the Court of First Instance in Dubai, which may be relevant. I can tell you, we don't want to tell you very much about it because of the danger of committing a tipping off offence. We understand the order's been made ex parte. It may not have been notified to the respondents yet. And so I want to say as little as possible. I can tell you that the amount in question is less than $10 million US. We raise it because Dr. Shetty might, if he were aware of the order, want to raise it. But we say it has no bearing for the reasons that the other orders against him have no bearing, because they don't protect Barclays' position.
No, and the position, well, I think I've heard enough to, I think we can go back out of in camera, can't we? And I'll just talk about those other orders. Is that all you wanted to say on that subject, Ms. O'Sullivan?
Yes, I just explained that the 8-day reason is that I understand that it will have had to come to light within 8 days in any event.
Yes. All right, good, thank you. Well, this will mark the end of the portion of the proceedings that were in camera and the end of the portion of the transcript that has to be redacted for a period of 8 days. Okay, now going back into open court, as it were, the position in relation to the other freezing orders, of which I am aware, of course, having made one, is that they're just irrelevant, as I understand your argument, because, of course, they don't give priority, they don't grant security, they simply restrain a dealing in the assets, and the fact that a number of people might have separate orders restraining dealings in the assets is really neither here nor there.
Yes.
That's your point, isn't it?
Yes, well, we're entitled to protect our own interests. These orders do not protect Barclays' own interests, and they don't offer it full protection against dealing because they may be varied or discharged without our knowledge or consent.
Yes, yes, indeed. All right. Well, unless there's anything else, Ms. O'Sullivan, I'm happy to give the short reasons for the conclusion to which I've come, and then we can talk about the mechanics of the order, if that's convenient.
I'm very grateful, my lord.
Yes, all right. Well, I'll give the reasons for the view to which I've come. This is an application for a worldwide freezing order against the respondent in respect of assets up to a value of $135 million US. The application is made ex parte in accordance with Part 25 of the rules of this court. I'm satisfied that there are good grounds for proceeding ex parte that are established by the evidence which has been filed in support of the application. The grounds upon which the application is made ex parte are the risk of dissipation of assets if the proceedings are delayed, and the difficulty of personal service on the respondent, Dr. Shetty, who is presently in India, where personal service is attended with considerable difficulty, a matter to which I'll return when we come to that part of the application which seeks alternative means of service. And I will make directions for alternative service later. And of course, because the proceeding is being brought ex parte, it's necessary to fix a return date within 3 days of today's date, which is on the 22nd of September, and I'll talk to counsel later about an appropriate time for that return date on the 22nd of September. The next matter to which I turn is the question of the jurisdiction of the court, because of course I would have to be satisfied as to that jurisdiction before making an order of this impact. Clause 20.2 of the guarantee upon which the claimant sues contains an express provision whereby the parties have submitted to the jurisdiction of the courts of the Dubai International Financial Centre, and I'm therefore satisfied that this court has jurisdiction. In terms of the power of this court to make the order sought, there is express power to make freezing orders in Part 25, and as the rules in that part make clear, that jurisdiction is not conditional upon it being established that there are assets within the area of the Dubai International Financial Centre if the court otherwise has jurisdiction. And for the reason I've just given, I'm satisfied the court does have jurisdiction and that therefore an order can be made in respect of assets wherever they may be found. Before I could make such an order, however, there are 4 requirements that must be satisfied consistently with the authorities which have been helpfully referred to in the skeleton of argument provided by the claimant. Firstly, there must be a good arguable case with respect to the substance of the claim. Counsel has taken me through the responses to the claim evident in the correspondence that have been received from lawyers acting on behalf of the respondent. They don't cause me to doubt that there is a good arguable case on the guarantee, which has characteristic clauses in it which effectively place a difficult onus upon a respondent to discharge the prima facie effect of certain acts that have been taken by the bank under the guarantee. Of course, this is not to say that Dr. Shetty might not have defences, but the materials that I've seen to date don't lead me to doubt that the claimant bank has a good arguable case in respect of the claim under the guarantee. The second matter which must be satisfied is that there are assets which might be available to satisfy a judgment in favour of the claimant. The evidence before me on that subject is quite clear and unambiguous. There is clear evidence that the respondent has many valuable assets in the United Arab Emirates and elsewhere, Some of those assets may also be subject to freezing orders made in other cases, and indeed I myself have made a freezing order against this respondent in another case. But as the freezing order simply restrains the dealing in assets, it doesn't grant security or have any impact upon the priority as between competing creditors. The fact that there are other freezing orders in existence, in my way of thinking, provides no reason for not making the freezing order sought in this case. The third matter, and the matter that I've given most attention to in the context of this ex parte application, concerns the requirement that the bank must satisfy me that there is a risk of dissipation of assets through the means of unjustifiable disposal of assets. And I emphasise the word unjustifiable. The mere fact of disposal of assets is not of itself sufficient to justify the grant of an order of this kind. There must be a real and not fanciful risk. The risk must be substantial, and it must be a risk of unjustifiable disposal. The claimant accepts, and I also accept, that there is no evidence of any disposal of assets, except in the case of the placement for sale on the market of one aircraft. And the evidence doesn't go so far as to suggest that that sale is itself an unjustifiable disposal. The grounds upon which the claimant relies for the proposition that there is nevertheless a sufficiently established risk of the disposal of assets in an unjustifiable way can be summarised in the following terms. Firstly, it said that there are allegations of widespread fraud throughout a large commercial group in which Dr. Shetty, the respondent, played a very significant part. It said that those allegations of fraud include an established propensity to conceal on the part of Dr. Shetty. It's also pointed to the fact that Dr. Shetty has assembled a significant network of international assets spread around the world, and again that is said to increase the possibility. I'm sorry, there are others on the line, I think. Yep. Okay. So there are assets spread around the world, again suggesting that there may have been an attempt to place assets beyond the reach of judgment. There is evidence that the market was misled in relation to shareholding in public listed companies and non-disclosure of documents relevant to that shareholding. It's also the case that Dr. Shetty remains in India, which is not his normal place of residence. His normal place of residence is in the United Arab Emirates. There was for a time, of course, a prohibition upon travel between the two, but according to the evidence, that prohibition on travel has been relaxed. So it would now be possible for Dr. Shetty to return to his normal home, but he hasn't done so. Reference is also made to the incentive which Dr. Shetty would have to preserve assets, given the very large number of substantial claims that have been foreshadowed against him and the corporate group which he assembled. The other matter to which attention is drawn is the fact that when Dr. Shetty's attention was drawn to the application for this freezing order, and it's clear that he was aware of it because his lawyers responded to emails that were sent to him on the subject. Dr. Shetty has not given instructions to either consent to this order or provided any counter-proposal for the provision of specific security for the bank's claim. So the proposition that's put to me is that the combination of all these things should result in the conclusion that there is a sufficient risk that Dr. Shetty will unjustifiably dispose of assets unless restrained by this order from doing so. I, of course, in assessing that proposition, I, of course, bear in mind that I'm proceeding ex parte, and that in that context, the benefit of any doubt should be given to a respondent who's not here to advance arguments on his own behalf, and I give full weight to that consideration. Of course, there will be a short return of this order, and the respondent will be given the opportunity to try and persuade me otherwise at some point in the future, even if this order is made. I am presently satisfied that the various factors to which I have referred in combination together lead to the conclusion that there is a sufficient risk of unjustified disposal of assets to justify the grant of this order ex parte on a short-term basis, and in the acceptance, of course, of the proposition that Dr. Shetty will be given the opposition to put his case in relation to these issues in the near future. The fourth matter which must be established is that it is just and convenient and appropriate to grant the order sought in all the circumstances of the case. The only reason for not granting the order in the circumstances to which I have referred would arise from the delay in bringing this application. The claimant and counsel on behalf of the claimant candidly concedes that the application could have been brought at an earlier date. Reasons have been given for the delay in making the application, which appear to me to provide some justification for that delay. I don't consider the delay to have been inordinate, nor is there any evidence of prejudice to Dr. Shetty by reason of that delay. And of course, the bank proffers a cross-undertaking as to damages in the event that it is later established that this injunction should not have been granted. And obviously there is no doubt as to the creditworthiness of the bank in relation to the satisfaction of that undertaking should it be called upon. So for those various reasons, I'm satisfied that all the requirements for the grant of an order have been made out on the evidence before me, and so I propose to make an order in the terms sought. There are two matters, I think, that need to be now dealt with, Ms. O'Sullivan. The first concerns your application for alternative service. As I suggested during the course of the reasons I've just given, I'm satisfied that there is a case for alternative service in these circumstances. And so I propose to make the orders that you seek in that regard. So there'll be orders for alternative service by reference to the various email addresses that you've identified in the order. The other matter that we have to turn to is the question of a return date. That has to be under Part 25, that has to be, as you point out, within 3 days, and I think that takes us to Tuesday, the 22nd of September. What would 12 noon be convenient to you, Ms. O'Sullivan, on that day? That would be 12 noon in Dubai. That would be, I don't know where you are. I assume you're in the UK. That might be 9 a.m. in the morning for you.
It is, and it would be therefore extremely convenient. Thank you.
Yes. All right. Well, I think I have to say that if the parties agree to adjourn that date, then of course it'll be adjourned. But as Dr. Shetty's not on the record, we can't presume anything. So I'll fix the return date then for 12 noon in Dubai time on Tuesday, the 22nd of September. So the order will remain in force until then, or until such further time as the parties might agree to adjourn this application. And costs, of course, would be reserved. Is there anything else, Ms. O'Sullivan?
It might be necessary to have a brief glance at some of the terms of the order. It is in the standard form. Just, yes. I mean, I've explained the limit sought. Although I notice, in fact, there's an error in my draft of paragraph 2.5 in that in one place the amount is incorrectly stated, so we'll need to correct that. Okay. The living expenses allowance, we've suggested $10,000 a week, but obviously that can be the subject of discussion with his lawyers if he says that's not sufficient.
Yes.
And as I've made clear,
the second reference in 2.5 should be 135 million rather than 130. Yes.
Correct. Yes. And the living allowance is at paragraph 4.1 under the exceptions.
Yes. Yes. Well, again, if it's agreed that if you agree on adjournment on the basis of modifications to the order, then again that can simply be done by consent.
Yes. Now, at the moment, the undertakings in Schedule B include what's usually called the Bavaguthu proviso. Yes. We will not seek to enforce elsewhere without the permission of this court. I anticipate that an application may well be made for permission in due course. Such applications are often made on a with notice basis. So we'll keep that under review. I noticed that there are a couple of redundant sections in Schedule B, in that 2C, for example, requires us to serve the claim form, which has already happened. And there's some duplication between 4 and 2D.
Yes.
So one of those, we can simply strike through those. But subject to that, I believe this is in the standard form.
Yes, well, I think we can take out 2C and D, and 4 in Schedule B.
Well, I think we will need to keep either 2D or 4. But
yes.
not.
Yes.
It doesn't matter which.
Yes. Yes, that's certainly right. Yes, all right. Well, your solicitors can sort all that out in dealing with registry, I'm sure.
Yes.
Yes.
So thank you very much. That's what we should do.
Yes, all right. All right, and the costs, I'm just looking at the draft order. You did specify costs reserved, didn't you?
Yes.
I think in the order, yes.
It should be reserved, yes.
Yes. All right. Is there anything else?
My lord, I don't believe there is.
All right. Well, thank you very much, Ms. O'Sullivan, for your assistance. The papers made it all very straightforward. They're very coherently and lucidly presented, for which I'm grateful to you and for those who instruct you. As I say, if once contact has been made with the respondent and his representatives, if there is an agreement to adjourn next Tuesday's hearing, then that can simply be done by consent.
Of course, and we will keep the court informed.
Good. Thank you very much. All right, well, that concludes the hearing then. Thank you very much for your assistance.
Thank you.